Good day to all. I hope you had a good week past and a great one ahead. Would like to remain positive, although the word has become negative somehow. What with this virus still hanging around for dear life? As I was saying, we would like to remain positive with our views and opinions. However, there are instances when we are face to face with a negative situation and we must tackle it right away. We have a few scenarios which were submitted to us and they have requested for anonymity. Thus, we respect this. But since these questions would need a legal mind, we have invited Attorney Alan Trinidad to give us his legal say or legal opinion. Friends, please welcome Attorney Alan Trinidad.
Good day. Thank you for the invitation, Ms. Pilar. It is my pleasure to be part of the program.
The pleasure is really mine, Attorney. I thank you for the positive response to our invitation. We have here some questions which we understand can only be properly answered by a legal mind. Therefore, we seek your answers. Case number 1, Attorney. Don't worry, Attorney. We picked only 4 out of many. This one is the case from DM. My father was admitted in a city hospital. At first, he was COVID negative. After 2 days, he was COVID positive. He had undergone plasma transfusion from 2 donors, and we were expecting him to be okay. But suddenly, his situation worsened. I am sure there had to be a mistake. He was getting well. So how can it be that he passed away just like that? What will our family do, Attorney? Do we have a case against the medical workers or the hospital?
Before we can answer this question, we should assume that the father was admitted not because of COVID, but because of underlying illness. And that underlying illness must have been very serious, or else he would not have risked being admitted to a hospital. With that said, we have to know if there is a cause of action. Meaning, was there any neglect on the part of the doctor or the hospital? And we have to find out with these questions. Number 1, where did the patient contract COVID? Was it before admission or during admission? If it was during admission, was there any neglect on the part of the hospital or any breach of their hospital protocol? And the second question is, what was the cause of death? Was it the underlying illness or was it COVID? If the cause of death was COVID, then we have to find out if there was a breach of the care that was expected of the doctor or the hospital according to the standard of care that was expected of them under the circumstance. These are the questions I would generally ask my client to find out if he has a cause of action to file a case.
Case number 2, Attorney, came from RG. I want to sue the hospital and the group of doctors and nurses who attended to my mother. She was asthmatic. She was not COVID positive, and a test is our proof. Why was she intubated? And since not one of us were allowed in the hospital, there was no way we could know.
There are 4 elements to prove medical negligence. The first is duty, meaning that there is a professional relationship between the doctor and the patient. The second element is breach, meaning that there is a breach of the standard of care expected of the medical professional under the circumstances. The third element is injury resulting from that breach. And the fourth element is the proximate cause, which means that the doctor caused the injury.
Therefore, Attorney, people do have an alternative and not just accept whatever is thrown at them as cause of death, right? They do have the law to turn to. I would like to know, where does our right to question begin when we are not medical practitioners? So, there is a law which can help those who are certain that a mistake had been committed. This is a comforting thought, Attorney. This brings us to the next situation, the case of BM. I once sued a doctor for a carpal tunnel operation which must have gone wrong because the pain which I suffered after the operation worsened than when I first consulted with the doctor. Should I not at least be refunded for the expenses? Please help. That's the case of BM, attorney.
When we file a malpractice suit, we should at least expect to be refunded for the expenses. That is called actual damages. There are other damages that we can claim under this suit. Moral damages for the pain that you have suffered, and exemplary damages if the doctor acted in bad faith or in a wanton, fraudulent, reckless, oppressive manner. Of course, you may also file at the same time a revocation of the medical license of the doctor before the PRC or the Professional Regulatory Commission.
This is the last question, attorney. From SI. I would like to ask for the law that helps people with medical complaints upon second opinion. There was no need to have an angioplasty. Please explain how this can help an ordinary citizen against a big hospital or its famous doctor. How are my chances of winning such a case? I have also been made to sign a waiver.
There are times when a doctor deems it necessary to do an angioplasty, and there are times that he will not. It all boils down to expertise and experience. From a lawyer's standpoint, it is no different from deciding on whether or not to file a case in order to protect the client's interest. As long as it benefits the client more than it harms him, then it will be deemed proper. At the end of the day, we go back to the standard of care. Is the action consistent with the latest standard of care? If it is, then there is no cause of action. If it deviates from the standard of care, then there is a cause of action. On the timing of the second opinion, one given after the fact, will have little or no bearing on the cause of action, because the second physician was not present prior or during the procedure. On the signing of the waiver, all waivers are subject to the umbrella condition that it is not contrary to law, morals, or customs. If there is a cause of action, we simply have to prove that the waiver was signed in violation of these conditions, or that the patient was made to sign under diminished capacity, or that the waiver was written in a language not understood by him. And this is particularly true for a patient with limited literacy.
Oh, so many learnings from you today, attorney. What would be your message to many more people in our audience who would be experiencing any of those we have just discussed?
I would like to advise a victim of a possible medical malpractice to immediately consult a lawyer. From initial consultations, the lawyer can immediately determine whether a cause of action exists or not.
Thank you very much, Attorney Alan Trinidad. We certainly appreciate what you have shared with us today. And we hope that you will consider future invites when we need a legal opinion again. Thank you, friends, for staying and becoming our regular viewers. We sincerely thank you all. For all of you out there who are struggling with the loss of a loved one, let me share with you this verse that you can hang on to in these trying times, found in 2 Corinthians 4:17 to 18. For our light and momentary troubles are achieving for us an eternal glory that far outweighs them all. So we fix our eyes not on what is seen, but on what is unseen, since what is seen is temporary, and what is unseen is eternal. Have a great week ahead, friends. See you next week.